What's up, everybody? Welcome back into the episode of The Lawyer You Know. And today we are going back to Massachusetts for yet another hearing, this time on the Myles King case, featuring Lally and Proctor. At least it was supposed to, but they never actually testified. We're going to talk about why and why this keeps getting delayed after all of the things have not been produced by the Commonwealth at this point. And again, we're looking at a very different situation as far as the evidence against a criminal defendant, but we feel the same way about prosecutors not doing their job appropriately and not caring about the constitutional rights about criminal defendants in Massachusetts. And we'll talk about how we get here, because that's the real big issue. How do we get here? How do we get into a situation like this? Is it prejudicial to the defendant? Is it always prejudicial? Where is that line? What is the defense going to argue? You guys had a lot of questions around this, which really made me interested in watching this hearing, even though seemingly not a ton happened. So let's get to it right now. All right. So we are going to pull this up here, and it is still a situation where Myles King is waiting for a lot of information, including search warrants. That Lally was on the stand, and they talked about what the DA's office does there and how Norfolk DA just kind of trusts MSP. And if they don't give something over, then, they basically just sit and wait, and they don't really chase it. They don't really do anything about it. The real problem is, if the prosecutor doesn't do their job, who is there to force them to? Who is there to enforce the rule of law? It's not going to be the cops, not going to be the prosecutor. Then it has to be the judge. If it's not the judge, then it has to be the legislature. And in this situation, Lally and Proctor are here again to testify, and we're going to hear what the judge does when he hears exactly what's going on here. And the questions I was getting initially is, the defense didn't do their job. The defense didn't tell the judge what was prejudicial. Why does the defense need to tell them what's prejudicial? Just because the Commonwealth didn't turn it over, isn't that prejudice enough? And we're going to answer those questions as we listen to this hearing together.
He didn't indicate that there was a conversation one way or the other. What he said to me is he needed to speak to Mr. Sullivan, and then he would get back to me. When I called again, I didn't get something affirmative in terms of, is that being discussed amongst the things that need to get resolved? Because this court has made it clear that you're not inclined to make a decision on my request for discovery until we get that order. And I just want to make sure we're not waiting until next week, and then all of a sudden someone says, now we need the order. So to the extent
I would like to see the February order.
And I conveyed that to them.
But I also have to deal with the issue of whether, regardless of what the order says, whether there's still a constitutional obligation on the DA's office to review the information that they are in possession of to determine whether it contains exculpatory information that should be produced in other cases. I appreciate the fact that somebody says you can't look at this or you can only look at it for a limited purpose, but I'm not sure that trumps the constitutional obligation that the DA's office has to review stuff. I'm trying to avoid having to decide that if we can get the authorization from the federal court so that we don't have conflicting orders. But we're not there quite yet. We need to run it to ground a little bit more, and hopefully we can get some movement this afternoon. I think I told everybody last time, out through the 11th. So I'm back the 12th. I'll see you the 12th. I'll see you the 13th. Whatever is convenient for everybody to get back together.
Judge, I appreciate that 100%. My concern is, if we know that we're running up against that clock that runs out on the 18th of August, is there a way that the government can now, or the Commonwealth can now ask the government to extend that order again? I don't want to be in a situation where you finally make a decision.
I think the Commonwealth understands that.
Yes.
And
you can't really guess at what they're understanding and what they're not understanding. That's one of the problems, number one. And he's talking about pushing the hearing and continuing to August 12th. We'll talk about that as they get kind of more into why and what's going to happen between now and then.
And I invited you the last time to seek to intervene or to, do whatever you needed to do to communicate your concerns to the feds.
I understand that, and that's what I did, Judge. I had a conversation with the U.S. Attorney's Office, had a conversation with their attorney, and the plan was, if we did not hear back in a way that was reasonable to us both myself and Attorney Sullivan plan to file a motion on Wednesday to intervene.
Okay, great.
That was what we were planning on doing. So
Okay.
that's before we knew that they weren't going to have a meeting until 4 o'clock on Tuesday, Judge.
Yeah. All right. So do you want to set a date? Do you want to say the 12th?
I think the 12th at 2 o'clock, just from my reading of the emails that was going around yesterday, seemed to be the best.
I think that's what Ms. Irwin said.
Sure. Yes,
Okay. So we'll put, let me just see, we will put,
except for Mr. Wester, I do want to say, who will still be on vacation.
right, we will put King, De Los Santos, Johnson, and Chanchillo, and I think also Walsh
Yes, please.
on for 2 o'clock on the 12th on the issue relating to the federal Proctor discovery.
Yes, Your Honor.
Thank you,
Okay.
Your Honor.
And
So that whole portion was them trying to get, more information from Proctor, cell phone information from the federal discovery. Again, not as important as a part of the hearing, but everything they're going to be pushing here is going to start focusing on to what the Commonwealth has not turned over.
is there any way to get an update from the 4 o'clock meeting today, Judge, so that we're not waiting until the 11th or the 12th, the morning of the 12th, to find out what happened?
I'm sure that the Commonwealth will alert folks to whether progress has been made. Everybody needs to be on the same page ultimately.
Why would you be sure of that at this point? Like, that would annoy me if I was the defense. I'd be like, Judge, they're not going to. They haven't done anything. They haven't done anything. Why will you just assume? Why can't you just order them to?
For the hearing on the 12th, and you're going to have to act quickly. The Commonwealth may have to act very quickly, depending on what happens.
And I've been doing that.
Yeah. Okay. Thank you.
Thank you.
Thank you, Your Honor.
All right. Now, with respect to the King matter, we're just dealing with the issue of the late disclosure, and
May I be heard, Your Honor?
sure.
At the close of the last hearing, you asked the defendant to provide the court with which documents were either exculpatory or would inhibit the defendant's right to a fair trial, would be prejudicial to him. I have not heard.
So this is the Commonwealth. They say, Judge, last hearing you said, defense, turn over everything to the prosecution that is exculpatory and prejudicial. That whatever we gave you, explain to the judge how it's prejudicial, and then he'll make a decision on this late or non-disclosure. Here's what I'll say. That is fair. That if something is not disclosed, in order for the case to get dismissed, right, it needs to be prejudicial. But the amount of discovery they didn't disclose, that should be an automatic disclosure. There should still be some kind of sanction or remedy to the defense. I'll say that, number one. But number two, prejudice sometimes is in the eye of the beholder, right? We've seen this in other cases where the same document or the same piece of evidence, one side will say, this is absolutely prejudicial, Judge. And the other side will be like, no big deal. Alec Baldwin's case, for example. Still to this day, people argue about whether that ammunition was prejudicial or not. But the non-disclosure was so egregious. And in my opinion, judges should look at this with a wide lens on what could even potentially be prejudicial for the Commonwealth, but prejudicial to the defense that they didn't get it, meaning somewhat good for the defense. It could be exculpatory, it could be impeachment, it could be something they could use to aid in their defense, something they could use to pick apart a prosecution witness. To me, I can argue almost anything's prejudicial, right? I was going to use as an example just now, what popped in my head is if there was a police report and there was a white page, it went page 1, 2, 3, 4, and page 3 was a blank page. But the last word on page 2, the next word on page 4 was a continuous sentence, and they just had a piece of paper in between. It's like, that's not prejudicial. I could say, well, Judge, I think it is prejudicial. That's not the way you're supposed to do reports. And if I want to cross-examine the detective that wrote this report and say, why was there a third page in here? Why did you pull it out? Why didn't you just leave the third page? Did they teach you to put a blank piece of paper in between? Is that how you do your police investigation on the case? Maybe not a big deal to you, maybe not a big deal to the jury, but maybe it is. Is that prejudicial? Judge could say no, but the defense could at least make an argument that it is prejudicial. And that's kind of what the judge wants from the defense, but you have to be able to have the information to do that if you're the defense. And that's where it gets interesting here. Crazy Cat Lady said, is this judge protecting the DA's office as well? It's too early to tell, in my opinion, with this judge. We're not going to jump to any conclusions with this judge yet. Ashley, they could have still questioned Lally and Proctor yesterday. So ridiculous. Here's what I'll say. I think there's probably some things they still could have questioned them about. The only way that maybe they wouldn't have to question Adam Lally and maybe Trooper Proctor, former Trooper Michael Proctor, maybe again Trooper Michael Proctor. I heard somebody talking about the fact that, well, he's right. This is kind of a side note, but Proctor's right. He was treated worse than other people because other people did horrible things and weren't fired at MSP. I'm like, yeah, okay, that's a great argument. It's like we all suck, but they didn't get fired. And I get non-disparate, treating people differently is not appropriate. But if you have cause to fire somebody, you have cause to fire somebody. Just because you didn't fire somebody else does not mean you should get your job back if you got fired for cause. There are legal arguments you can make, but that's not one of them. That's another video. Sorry. So I didn't even end up answering that. So they could call Proctor and Lally, but if there's nothing prejudicial and the judge is going to say, none of this matters, it's all, just mumbo jumbo that you don't even need for the case, it's not relevant, it's not prejudicial, then maybe we don't even have to call them at all. So he wants to wait and see what's actually there before he puts these people back on the stand, I guess. Diva Dawn, hey, Peter, welcome back. Do you think Karen Reed will be used as a case study in law school going forward, considering how much corruption her case brought to light? I think there are some aspects that if I was a law professor, I would use it because a lot of people watched it. It was interesting. It was a one of one, but I don't think it was like a very novel case law type of case. Like I actually think, what was their name? The Crumbleys in Michigan was more interesting as far as how case law and statutes were applied. And if you want to compare that to Baldwin and the difference in statutes with similar types of cases, and that is more interesting from a law school kind of thought projection, but a trial ad class, Karen Reed's case would be great. There's a lot of aspects I feel like I could use if I was a law professor. How come they are only getting pieces of discovery still 4 years later? They don't have everything. Wow. And that's the problem. That's the problem, that even if not a shred of this is prejudicial, it's all discoverable. It was all requested and they failed to disclose a lot of it. So there's got to be some kind of sanction and remedy here, regardless of if the case gets dismissed or the judge finds it to be prejudicial, anything like that. Peter, I understand how mass works. The judge has to deal with irremediable in regards to Brady. Can you please make it make sense? Thank you. So we're going to watch it. In order for it to be Brady, it's got to be prejudicial, right? In order for it to be exculpatory, it has to be prejudicial. It's got to be proving the defendant's innocence or casting doubt on the defendant's guilt or impeaching a witness, right? It's got to be good for the defendant in order for it to be Brady, and that's the point. Just because there's a picture of my hand in Myles King's file and they don't turn it over, they still should have because it's in his file for whatever reason, right? But it's not prejudicial. Doesn't prove anything in this case. Doesn't disprove anything in this case. It's not impeaching to anything in this case. So that's kind of the thought exercise the judge needs to go through and the balancing that the judge needs to go through in this case specifically with all the stuff that was not turned over. I would be shocked. I would be absolutely shocked if this lawyer, who seems like a very good lawyer, cannot come up with some reasons why what was not turned over is prejudicial. So that's my guess as to what happens here in the near future.
Of one document, since these have been provided in April and May. And to that end, I'd ask the court to order that right now. I think that this has gone on. This is now the second day of a hearing, and the Commonwealth is unaware of which document or which documents are prejudicial to the defendant and will prevent him from having a fair trial.
This lawyer says that with a straight face, knowing what's coming from the defense. He's like, Judge, they didn't tell us what's prejudicial and what's not. And wait till the defense acts or explains what's happening, because they can't at this point. Or if they did, they're just going to be spinning their wheels. Because who's going to tell us we have to follow the laws? We're in Massachusetts, grifter, servants. It's just the way we do things in Massachusetts, Mr. Jackson. People have a lot of strong feelings about this, and I get it. Holly, a little foreshadowing about what happened. They handed them things like as they're walking in and they're about to explain, the defense is about to explain. It's like, Judge, if they just keep giving us stuff, I'm going to have to keep going over what is prejudicial and what's not. Because if they give me one thing and it might not seem prejudicial, then they give me another thing that's like, oh, that is prejudicial. That's contradictory. This is a new report by this officer, which is different from the last one, which means I could impeach him from the search warrant to this report. But if they don't give me this report, I don't know that it's impeachment. See how that works? The more you get, the more you can use. So if I don't know about it, how do I know if it's going to be prejudicial or not? Kel said, this is like finding a freezer full of bodies Proctor and the entire Commonwealth has been hiding. Yeah, but it's like finding it and then being like, well, none of these bodies are Myles King, so nothing to see here. It's like, no, we can't be having stuff like this. We can't be having stuff like this.
We had two things I was looking for. I was looking for that, and I was also looking for some sort of a agreement of the parties, if it was worked out, to identify which of the documents were newly disclosed, which were partially disclosed previously and fully disclosed more recently. And then there was the prejudice analysis as to the new documents.
Correct.
So there was sort of
And that's the other thing is what's newly disclosed. What have they just disclosed now versus what's been disclosed all along? That's important.
a two-phased process. I don't know whether either one of those phases happened, whether the parties met and tried to work out an agreed list as to what was new or what was not new.
I endeavored to work with ADA Hickman to ensure Your Honor had a complete list as diligently and as best as we could of what documents were previously produced, and that was provided to Your Honor. I believe was sitting on your desk as Monday morning. It was a third exhibit that the Commonwealth provided. We did confer on Friday afternoon. It was represented to me that counsel would be providing us a disagreed list or a number of other lists to show the court what they disagreed with.
I got a pile of documents.
And we got that as well.
This is the pile that I got, I think, from Mr. Viccio's office. I don't know if included in there is the chart that you folks worked out that you say was on my desk. I'm not sure I know what you're referring to in terms of a list that was new or not new, but maybe it is in the stack.
It's a table. It's the third. If you look in the manila folder that's underneath that, there, in a rubber band, it's in your hands right now.
Oh, in here, okay, this one.
That, yes. The third doc.
Okay,
That is what I prepared with the assistance of ADA Hickman.
okay,
Which specifically describes what, if anything, is
okay.
minorly different. That was provided to counsel.
What, if anything, is minorly different? Like, this may seem like an unsuspecting hearing, but you're hearing how frustrating it is. And this is kind of like a microcosm for a bunch of bad prosecutors, because there's a lot of amazing prosecutors and you don't have a lot of hearings like this with really good prosecutors. But it's like lazy prosecutors always poo-poo everything. It's like, no big deal. Mr. Trago's trying to make a big deal again about nothing. It's like, Judge, there were minor differences. What's the big deal? But we know some juries, in some cases, that makes a very big difference. A very big difference. Peter, is there a reason why they can't just give everything to them at once and say they have everything? I don't understand why they can't do it now. So there's a couple things. I'm not going to accuse them of trying to hide anything, but sometimes the prosecutors don't want to turn over certain things. Sometimes it's not relevant. Sometimes it's not discoverable. Sometimes it's work product. Sometimes it's protected. You know, like the Proctor text messages, they feel like they have a good fight to keep that out, whatever. So it's okay to object to certain things. It makes no logical sense to me why they haven't given all the search warrants, things that were done in the grand jury proceedings. Like, it makes no sense to me. Somebody needs to break it down to me like I'm 5 years old, because it doesn't make any sense to me why it is this difficult. And sometimes when you're a defense attorney, you go in there and you're like, Judge, we do this all the time, and this just is not how it's done. And the judge sits up there and doesn't act as flabbergasted as you do. It can be very frustrating as a criminal defense lawyer to deal with that. Why do you think Rosemary didn't fight harder for questioning Lally Proctor in the afternoon? She looked defeated. So one of the other things, I don't know what she looked like, if she was defeated or not. I don't have a comment on that necessarily. But one thing, if I was the defense attorney and you're a good defense attorney, preparation is key. You have to be prepared. And if she doesn't have all the documents, maybe she felt like she wasn't fully prepared to eviscerate them the way that she could if she did have all the documents. Maybe she thought with more time and preparation, more discovery, to make sure the Commonwealth says, okay, now you have everything, that if she doesn't have something, she can hammer Lally or hammer Proctor. Where is this? Why don't I have it? They said I have everything. versus going in there where the prosecutors are still saying, oh, we may still turn something over to you tomorrow. So maybe she's just not as prepared as she would be if she had everything. And again, she might feel defeated because it's so annoying that over and over again, these late disclosures right before the hearing, you don't know what you have and what you don't have. And as a lawyer, that's a nightmare. It's an absolute nightmare if you don't know what you have and you don't know what you don't have.
On Thursday last week, we got a teleconference on Friday, and counsel was working on their own lists.
Okay.
So to answer your question, no, there was no agreements as of now. We endeavored to meet earlier and understand from my pleading what counsel disagreed with, but that was not reached. We provided you, the Commonwealth has provided you as best we can what has been previously provided.
Okay.
If there's any subtle differences, we can supplement that at a later date, but at this point, I know ADA Hickman has worked very hard to go through the material.
Attorney Scapicchio?
Thank you, Your Honor. So we've provided 3 charts, both to the Commonwealth and to the court. The first chart deals with the information contained in the Commonwealth opposition in disputed documents from pages 7 and 8 of their motion to dismiss. The second chart deals with all of the new discovery, which I thought we were in agreement that the second chart is everything that was new, it hasn't been disputed by the Commonwealth. And the third chart is the information.
So you have 2 dueling charts, huh? So you have the Commonwealth chart and your chart.
Yes,
This is exactly what I didn't want to have happen.
I understand, Judge.
Yeah, Judge. And that's exactly why I'm sure the Commonwealth is going to do that. I'm sure the Commonwealth knows by now. I just wouldn't be cool with that, right? I don't know this judge. I don't have any beef with this judge, but at some point you have to be like, okay, these lawyers are not working well with each other. They're not yelling at each other. They're not angry at each other. And that's good. They're being cordial and professional, but especially the defense just does not think the Commonwealth is doing its job. And after seeing Lally on the stand, if I'm the judge, I'm like, yeah, I'm going to have to grease these wheels a little bit. Like, to me, that's important. And the fact that they have different charts, even though you clearly didn't want that, that's telling you that there's some trust broken there and you need to be more hands-on as a judge.
So why didn't you get together and work, figure out a...
I tried you.
Well, I think we both tried.
And the Commonwealth says, oh, I tried to, Judge. I tried to. It's like, brother, I have no sympathy for you at this point. No sympathy for you at this point. Because the proof is in the pudding in this case. And again, that's why I would be frustrated if I was the defense lawyer and the judge wasn't more frustrated with the other side. I had a case recently where the judge absolutely lambasted the other side after a hearing in his order. I was shocked. It was unlike something that most judges do, but I absolutely loved it because I'm like, thank you, judge. You feel my pain. They were trying to block things and say they didn't have to turn over text messages and saying that, oh, they had it on auto delete when in their prior deposition, they didn't say that. They said they still had the text messages, but they didn't turn them over. It's like, what are we trying to do here? And the judge hammered them, said they're not allowed to use the text messages anymore, good or bad. And we get a negative inference. So we get to argue to the trier of fact that whatever was in those text messages is good for us and bad for them. And that's exactly how it should be. I don't know why I was surprised, but I was.
I'm playing catch up here, Judge. They've had this information since 2021. I'm trying to go through it, organize it, and figure out where it fits in the most timely fashion that I can. And that's what I've spent my time doing. So when we spoke on Friday.
Do I have a list of the items which are new or which you claim to be new and that I can then cross-reference against the Commonwealth list, which you say are prejudicial or are exculpatory and you're behind the 8 ball because of the late disclosure. Now
he gets that, right? He's like, now I understand why you didn't give me what's prejudicial because you're behind the 8 ball because of the late disclosure. It's like, yeah, just perpetually behind the 8 ball because of the late and non-disclosures. That's the problem. And just wait till you hear what the judge is going to do for them, which for the DA, who cares? My government check is clearing, right? Whether I'm sitting down there with her going through documents or I'm back in my office or if I'm in another courtroom, I don't really care. I'm getting paid the same. But when you make a defense attorney sit there for 3 hours and go through these documents, that's taking away from them working on other cases. That actually hurts their pocketbook potentially. Not that anybody cares about it or feels bad for defense attorneys, and she took this case and wants to do a good job, but that's why it's annoying. If you would have given it to me last week, I could have done it when I booked time for it and been prepared for this hearing and be done. Now I got to waste 3 hours today going through documents, block another day off my calendar to come in here, block more days off to prepare, and it's just incredibly frustrating. Incredibly frustrating. Peter, when the prosecutor poo-poos something or poo-poos you, can you come right back at them with why they're wrong? Yeah, respectfully, and yes, you absolutely can. The problem is it depends where you are, right? If you know the judge and you have a good relationship with the judge trusts you and knows that if you say something, it's true, this can be very effective. If you're in a jurisdiction that you're not often there, or if the judge has a really good relationship with the prosecutor, and it's kind of like a he said, she said, it's kind of like if two strangers come tell you opposing things, you might not automatically believe one of them. If two friends come and tell you opposing things, you might not automatically believe one of them. If it's one friend and one person you don't know, more likely to believe your friend. So it's all on the judge's perception of how the facts are being explained to him, right? Is he like, oh, this lawyer always exaggerates everything, it's probably not as bad as she's saying? I don't know, but that's the only explanation I can think because it seems obvious to me. Michelle, I feel like it's difficult to do piecemeal because it's hard to see what might be prejudicial until you have everything. You don't know what you don't know. Yeah, exactly. And it's even harder last minute. And frankly, that's how you get in trouble. If you try to jump in and make an argument without knowing what you have and what you don't have, that's exactly how you get in trouble.
Standing the continuance.
Yes, Your Honor.
Okay, where will I find that?
Where we find what, Judge?
Your list of the explanation of why particular things are prejudicial to you.
That hasn't been completed yet, Judge.
Okay.
I just got to the point where I was able to send a list to them literally Monday morning saying, based on everything that you provided since April, here's what I think is new, and we all agree it's new. That's chart number 2. Here are my disputes from what you say you already gave us from the first part of your motion, and here's what we say is new from the second part of your motion. That's what I was able to accomplish in the week that we had between now and the last hearing.
All right. So you need more time to.
And that seems like a lot of work to me, right? Here's what's new. Here's what's old. Here's what we all agree is new. Here's what we all agree is old. And here's the differences, Judge. Here's what we disagree on. That's making it about as easy as you can for the judge.
You get the other stuff done.
I do.
Okay. How much time do you need?
It depends. I just got more discovery this morning, Judge. So
I mean, that's crazy. So she was going to show up and she was supposed to prepare to argue things were prejudicial, not prejudicial, question Lally, question Proctor, and he hands her new discovery today. Now, how much is it? Is it one piece of paper? Is it 100 pieces of paper? That makes a difference. But you cannot, as a judge, expect a lawyer to be prepared when they're handed what we've been arguing and fighting about for 4 years today, the day of the hearing. I've also had a judge sanction another side for doing that exact thing. I file a motion to compel, judge grants it, they still don't turn it over. We file another motion to compel, they give it to us the day of the hearing. Guess what? They had to pay all my attorney's fees and costs for prepping all those documents, showing up to the hearing, arguing at that hearing. They had to pay it all. They paid it personally. The law firm paid it. They didn't even make the client pay it.
Just keeps happening. So in order for me to get my hands around it, they have to be able to certify that I have everything, Judge. So I can't keep doing this.
It's like we have to have a closed door. We've got to shut off the spigot for a second for me to be able to make these arguments, Judge, and me to be able to figure out, is this an email that they just got on August 2nd? Because then it's not a late disclosure. Is it from 3 years ago and they should have turned it over? Then it's a late disclosure. The analysis is not just, is it good for me? Is it bad for me? When did I get it? Do I already have it? Is it good for me? Is it bad for me? Because that's the other thing is the piecemeal stuff. There's always, I don't know any prosecutor's office that makes sure they don't send you any duplicates. Because usually it's like, okay, here's 100 documents. Here's 150. Well, 20 of the 150 were in this 100, or maybe all 100, and it's just a new 50, but they give you 150. Well, you have to figure that out as a lawyer. It's part of our job, right? Document review, boring stuff, our eyes bleeding because we read so much, or our associates do. God bless them. But that's part of the life that we have to do, which is why you can't just hand me a stack of papers on the day of the hearing and expect me to be able to be prepared and move forward on it.
Piecemeal, the way that they've asked me to do it over the last month and a half.
Okay.
Between now and the last hearing.
All right. So you need more time to get the other stuff done.
I do.
Okay. How much time do you need?
It depends. I just got more discovery this morning, Judge, so it just keeps happening. So in order for me to get my hands around it, they have to be able to certify that I have everything, Judge. So I can't keep doing this piecemeal the way that they've asked me to do it over the last month and a half. So do we have everything? Because if we do, I'm happy to sit down and say, this is where we are and this is where we stand. But if we don't have everything and we're going to come back in a week and they're going to hand me something else in the morning of the hearing and say, this is,
Well,
now this
as
is
an initial,
If I'm the judge, as soon as she says, and the prosecutor does not deny or argue with the fact that she was just handed new discovery today, I'm like, yeah, sir, that can't happen. You have until Friday to give her everything. And if you don't disclose something that's 3 years old or you should have disclosed, it's going to be struck. So go do your job, put the screws to him, make him do it. But that's not how he responds, which is kind of frustrating for me. I would be frustrated if I was this defense attorney with how the judge handled this.
crack, I wanted a list of what was new.
Oh, this
As
is-
an initial crack, I wanted a list of what was new and what was prejudicial in the 2 notices as of when the motion to dismiss was filed.
Yes.
That's what I think we were shooting for. We
And that-
understood that some new stuff had been produced after that.
Yes.
And I don't know what the explanation is for that, but in any event, we're looking at what.
I don't know what the explanation is for that, but in any event, let's just continue on. It's like, no, I'd like that explanation. Because again, and I don't know if this lawyer goes into it harder, but I would really be arguing, Judge, the new things they discovered to me can affect what we already have and whether or not it's prejudicial. So I need to be able to answer your question appropriately for my client, and I can't because they keep giving more and more and more discovery piecemeal. And I'm surprised the judge isn't picking up on that more.
Was filed as of the time the motion to, what was new as of the time the motion to dismiss was filed.
So Judge, what I did with the new information is I put it in chart 2 as just a description of it. I cross-referenced it to a bait stamp number if we had it, and I put it in a discovery category, which is I thought what the court asked me to do. So some of it has to do with jail calls, some of it has to do with social media, some of it has to do with search warrants. I've categorized it in a way that I think that I was hoping it would help the court understand.
Can we make a record here?
Yes.
You were referring to lots of stuff which is not in the record.
Correct.
Right? We admitted in the last hearing exactly 1 document,
Yes.
right? If you are referring to particular charts, let's be clear about what they are. Let's mark them as an exhibit. And then we'll discuss what we need to do. You can explain what those documents are to me without a witness. I think that's sufficient. And then we'll decide whether we're going to proceed with the hearing on an evidentiary basis today or not.
Priya asks, why can't the judge ask the Commonwealth why they are still turning things over? Oh, he can. He could press big time on that. Linda said, I'm sorry, not the Commonwealth is corrupt, business as usual. Why didn't the judge call Proctor? Why delay, kick the can? I think the Commonwealth is doing everything they can to delay or not have to call Lally and Proctor. So if they can fight about the documents and win on the documents and get this judge to be on their side and call no harm, no foul, they are going to do everything they can to do that and push that. I do think that. But I will also say, it sucks and it's not fun for Lally or Proctor to continuously have to show up for a hearing that you think you're going to be called as a witness and grilled on and you don't get called. That's annoying. It's not like they love this either.
All right. So I've been handed 3 charts. Chart 1, chart 2, and chart 3. You're moving their admission?
Yes, Your Honor.
Okay. Any objection, at least for the record here?
No objection.
Okay, so these will be marked as, unfortunately, exhibits 2, 3, and 4, because we already have an exhibit 1.
And may I admit the Commonwealth's exhibit,
Um,
that, the chart.
This is the Commonwealth exhibit. Any
Yes.
problem with this?
No, Your Honor.
Okay, so this
They're
will be
right.
exhibit 5.
Thank you, Your Honor.
How do I read them? They look like you're talking past. All right, how do I deal with these charts? How do I read them? They look like you're.
I feel like she's told us already, but okay.
talking past each other to some extent, that they're not, that so if I look on Exhibit 2, which is the defense chart number 1, discover.
So Welchers, defense had a list of disputed items. Why didn't the judge use them to assist them in working that out? Well, it seems like he didn't know how to read the chart. But he gives them the way that he wants them to work it out, which we'll hear near the end of this hearing. Kyle, thank you so much for the super sticker.
Address in Commonwealth opposition to our motion to dismiss. Item 1, copy of search warrant affidavit for T-Mobile cell phone. Draft affidavit. What does this tell me?
So what that's meant to tell you, Judge, is that the Commonwealth is, in their pleadings, are indicating that we actually got the search warrants. We didn't get the search warrants.
No, hold on. Not argument, just what does this show? Document description is received.
He said, what is this supposed to tell me? And she starts making her argument about what it's supposed to tell her. He's like, no argument. It's like, felt like you were asking for her argument there.
By King.
Right.
What is that? What's in that column?
So that column is what we actually received as opposed to what the Commonwealth is claiming they gave us. And it's categorized. So the Commonwealth is claiming, so for the first 2, Judge, if I can just show you, for the first 2, the Commonwealth is claiming that they already provided those search warrants to us. They haven't provided the search warrants to us, Judge. In fact, what they provided to us was...
No. Just slow down. I want to understand what Exhibit 2 shows.
So Exhibit 2 takes the Commonwealth's opposition.
What's in column 1?
Column 1 is the description that was received by us.
You're
from
quoting
Commonwealth.
Something from what?
Discovery notices, Judge.
Draft affidavit for search warrant 21 SW. I'm sorry, you're quoting what?
We're quoting what the Commonwealth named these documents in their opposition, Judge. That's what the Commonwealth named these documents. To try to convince the court.
I would think if you read the motions and the opposition that you would know that, but I don't know. At the beginning, before the judge came in, Rosemary offered to buy the Commonwealth a bait stamp, LOL. Yeah, I mean, we know they can afford it, right? We know they can afford it. Someone told this judge to do the right thing. Oof. Young Jerks channel is my go-to for live court. They do a really good job of making it easy to find and watch. So shout to the Young Jerks.
That we already had them. This search warrant stuff down there. The 2.
Okay, and you don't have any Bates numbers here, so I can't go and find these things, right?
Right, because the Commonwealth didn't have the bait stamps and the ones that we did.
Hey, guess who else can't go and find it, Judge? The defense. Bait stamps would be great. That makes it easier on all of us. Why don't you tell them to make it easy and organized for you to find and for us to find, Judge? Wouldn't that be nice? Like just him looking at this chart and trying to figure this chart out, right? Look at how long it's taking and how many questions he's asking. I also skipped a couple minutes here. So think about that. And now think about the defense who's handed a bunch of documents. They don't know what they are. They don't know how they're organized. They don't even know what they're responsive to. And they're trying to figure out just to create this chart, let alone find what's prejudicial and what's not prejudicial.
So if you look down to the second column, we do have bait stamps. There were some things that were given.
Second column?
Second part of the chart. We were able to provide bait stamps.
Second chart? Or
No, just where it says notice 4925.
All right. So how do I compare what you have to what the Commonwealth has provided me? I need you to be on the same page. I need you to go.
Hey, no, Judge. Like at some point, I'm going to say, no, Judge, you don't. It's an adversarial process. We don't agree. They're not giving us anything. They're saying they gave it to us. They're not. You need to make some decisions, Judge. I know some judges don't love to make decisions. I always tell you what's my favorite quality in a judge. You guys know. What is my favorite quality in a judge? Decisiveness. Because even if they make the wrong decision, at least they're decisive and it's on the record. I can go appeal it. I can go fight it. But like judges that just like, can't you all just get along? Can't you guys go back there and work it out? It's like, Judge, you need us to be on the same page. We are clearly not on the same page. I wish we were on the same page too, but we're not. So, Judge, I'm sorry. I apologize to the court, but we are not on the same page. Here's what we agree with. Here's what we disagree with. Here's what you need to make the decisions on.
Through every single document.
This is not unusual, by the way. Lots of judges don't want to make a call, want the lawyers to agree, figure it out. Can't you guys just tell me what we're doing? What's agreed upon? What's not? Lots of judges do that.
That was produced that you base your motion to dismiss on. Every single one.
Mhm.
You have to address every single one, okay? And you have to make a chart saying this was produced in Discovery Packet 1. This was never produced before, okay? I don't need argument.
Think about the work. Think about the work that is. You have to go find when they produced it, what discovery packet they produced it in. Oof.
Associated with it. I just need to know the universe of the problem. I need to get my arms around the scope of the problem. And then I need to know, with respect to anything that's new or substantially new or partially new, why you're prejudiced by the late disclosure of that additional information.
Understood, Judge.
So I don't have that here, right?
I thought you did. I understand
Okay.
now you don't follow it the way that I followed it.
Well, I don't understand it. So I need you to explain to me why you think I do have that, if I do.
Well, I think you have part of it, Judge. I don't think you have all of it.
All right. So I need all of it.
Okay.
Okay. So I understand the
I would be like, so do we, Judge. If I wanted to be a little sarcastic with the judge, I'd be like, so do we. The bar is so high for the defense in mass, and prescribed remedies, bail and continuance have already been given. In my opinion, it seems to frustrate justice. It feels like the judge is playing dumb. What is happening, Crazy Cat Lady said, is the judge acting a little ignorant. He seems to be making it more difficult for the defense. Here's what I'll say. The Commonwealth should be able to prove what they've turned over and what's new and what's not too. So why does the defense have to do all this? And if I'm the defense, I'm not trusting the Commonwealth. So even if they do it, I'm going to do it on my own as well. But both sides should have to come up with a list of what's new and what's not new. Why does just one side have to do this? We'll see what he says at the end here.
scope of the problem. And then I can analyze the question of prejudice. After you've analyzed the question of prejudice.
Yes, Judge.
So how are we going to do this?
We're here at 9:24. I'd be happy to meet with the parties downstairs for the next 3 hours.
I'm sure you would. And I don't mean any offense to that to a prosecutor, but I'm sure you would, sir. I got other stuff to do. If we're not having this hearing today, which, yeah, sure, I have the next 3 hours blocked for this hearing. But if we're not doing this hearing, that means I got to block 3 hours another day or more. And now they've doubled up the time here that I'm going to be sitting, hanging out with you, working on this case because you didn't do your job when you should have. Now, of course, nobody's going to say that. And she's going to say, yes, okay, I'll do it. But that's what's about to happen here. Is this guy who's got his caseload and, you know, any difficult cases they bring a special prosecutor in for, and, you know, he's making his paycheck. He's going to go back there and work on this case. But she's got multiple lawyers there. She's got multiple cases her office is handling. This is much more difficult for her. And it just keeps happening. And the judge should at least be able to recognize, even if nothing is prejudicial, if literally nothing is prejudicial that was turned over late or not turned over at all, this problem was absolutely created by the Commonwealth. The defense did nothing to create this problem. I think we can all agree there. I think even the judge agrees, right? Granting bail here. So why is this the demeanor here in the courtroom?
I think it
Michelle said Lally should have to go too. Yeah, have him sit at the table and talk about what's been disclosed and what happens.
would be a much more productive use of time than putting Mr. Lally back on the stand or anybody else. Because there are real constraints on the court's ability to provide a remedy beyond the remedy that has already been provided, absent real showing of meaningful prejudice. And so I need to understand where that prejudice is coming from. And
He keeps saying prejudice, and I get it, and we'll get there. But it's like, before we get to what's prejudice, Judge, you need to do something for me. You need to order them by Friday that I will have everything. Then I'll be able to make my arguments about what's prejudicial or not. Then I'll know what to question Lally and Proctor about. Until you do your job there, I can't do my job appropriately. That's the reality of the situation we're in here. I never heard that the defense had to say why they're prejudiced on every single exhibit. That's crazy. More than 300 docs just turned over again. It has to be prejudicial in order to get a remedy like dismissing the case, right? Just because something wasn't turned over, you don't want to put the bad guys back out on the streets. I get it. Constitutional rights, hold them to it, do things the right way. I get it. But just because they didn't turn over a shoelace that's not relevant or not prejudicial, we can't let people out for that. It has to be for real information. If they were trying to hide exculpatory information, impeachment evidence, then yes, the ultimate remedy. And it is on the fault of, and they have to sleep with it at night, the prosecutors, law enforcement. It's their fault, not a criminal defense lawyer's fault. So that's incredibly important. But yes, in this situation, you always have to show prejudice. Now, most good defense lawyers, like I said in the beginning, can show you prejudice to just about anything. Isn't this something the judge's clerk could do? What, like explain to him what this document means? Theoretically, I guess it could. Commonwealth's motto, if I don't do my job, meh, the defense will do it for me. I mean, only if the judge makes them, and that's what sucks about it. Especially because the Commonwealth has had this stuff for 4 years. They know what's what. They should, at least. It's all new to the defense the first time they're ever seeing it 4 years into a case. Much more difficult to get your arms around. Kind of like you're having difficulty here, Judge, because it's the first time you're seeing it. That's the boat we're in. It's not the boat the Commonwealth is in.
So you're welcome to spend the next 3 hours doing that.
Sure, Your Honor.
Okay. I know everybody's here. I know we have witnesses here. I'm sorry about that, but I think we need to do this in a logical order.
Thank you, Your Honor.
I have a hearing at noon, from noon to 1, where I have to finish an evidentiary hearing in another 2 co-defendant case. That'll take me from noon to 1 o'clock. I'm happy to see you at 2 if you're able to make substantive progress between now and then, or I'm happy to just see you on the 12th.
I don't
But
know
the
where-
12th would not be for evidence. It would be for an explanation of the,
Then we're going to have another hearing. So we had this hearing to set up the next hearing, to set up the hearing to do what we came to this hearing to do. And this is why people complain about the justice system, how slow it moves, how laborious it is, how difficult it is. I loved watching this hearing personally. I know a lot of people maybe thought it was boring, but I saw the questions and the comments coming out after, and I was like, I can't wait to talk about it. Because guess what, folks? These types of things, you need to see it. This is not how the judicial system should work. Good judges and good prosecutors, I think, do better at holding lawyers' feet to the fire and being prepared and not let you come in there and tell me I haven't turned over things that are 4 years old. You better believe I'm going to be pounding that table like that is not true. That's impossible, Judge. No way did my office not turn over something that was obviously discovered. Now, I'm not going to say I won't argue and say you shouldn't get it and maybe I'll lose and I have to turn it over a year later after we have a couple hearings. Sure, that happens. But no way should anybody ever be able to say this about another lawyer.
analysis that you've done on all the various documents that were apparently produced late.
I don't know where we'll get it. I mean, we could let the clerks know if we could,
I'm happy to report back at 2, Judge, if that's what you
Yeah.
want us to do.
I would like to release the witnesses.
Yeah, I think you should release the witnesses. I think and I think frankly, I should see you on the 12th, because if you're not done by 12 or whenever today, we're going to be together on the 12th. It's the soonest I can see you after today in any event. And it'll allow you to do the prejudice analysis, because that's the first part of it. That's great. Everybody's on the same page as to what's new.
Mhm.
And then I need to hear from defense counsel document by document as to why it's prejudicial that this was lately disclosed.
Yes, Your Honor.
They don't have to do all 300 documents, just the ones they believe to be prejudicial, by the way, in case that wasn't clear. So if they only think 5 are prejudicial, only 5, I mean, that's a lot. But whichever ones they believe are prejudicial, those are the ones they need to go document by document on. I think there will be a lot.
Your Honor, if I may, I believe we have one outstanding issue that was brought to the court's attention, and I believe Attorney Moynihan is here.
We're done.
We had the order of Judge Doolin of June 17th relative to Mr. Proctor's personal phone, and Attorney Moynihan has filed a motion on our last date relative to that order. And I wondered if we could address that today. It's the one outstanding issue that we have on Judge Doolin's June 17th ruling relative to Mr. Proctor's personal phone, Your Honor.
Judge, I didn't know we were addressing that today.
My understanding on the last date, Your Honor, is we
Meaning you shouldn't address it today. If the defense lawyer says they didn't know they were addressing it, meaning they're not prepared to argue it, can't deal with it today.
put it down for noon because Attorney Moynihan would be here, and today would be the day that we'd be addressing this issue relative to Judge Doolin's order. I believe I asked the court on our last date whether or not this needed to go back to Judge Doolin, and Your Honor indicated that you had read the order and felt that you could make a decision.
Frankly, Your Honor, I didn't know we were addressing that today.
Would you like to be here on the 12th also?
I would need to check, but if I could be available on the 12th, but that would be a better day than today.
Okay.
You want to check? You have your calendar?
Sorry,
You have your calendar?
I'd have to just call my office.
Okay. Let's put it on for the 12th. Call your office. If for some reason you're unavailable, let me know. I'll get back on the bench and we'll set another time.
Is that 2 o'clock, Your Honor?
It would be 2 o'clock, yes. I have the papers here. I didn't read them for this hearing, but I will take a look at them now. So
If he didn't read them either, that means the judge and this defense attorney were like, we didn't think we were handling him here. If the judge doesn't think it, then you're not going to handle him at this hearing.
if you decide you want to be heard today, I'll hear you on it.
I prefer the 12th. I can let the clerk know if I'm available. So I believe I can be available.
Okay, all right. So if you can be available, we'll hear you on the 12th. Otherwise, let the clerk know and I'll hear you now, okay? Okay. Anything else we can do today? Thank you.
Thank you.
So after that, the defense attorney and the Commonwealth go back for 3 hours and go through this stuff. I mean, that's assuming they used the full 3 hours or only 3 hours. Yeah, I saw a bunch of comments about the differences in judges makes a big difference. You guys are being able to see it, right? I see it in real life and practice it. And I know, we sit around the office and talk about, we're like, oh, we got this judge on this case. Yes, we got this judge on this case. And it's not like some judge is going to give us, Peter Tragos walks in, you automatically win. That's not how it works. Just like we know they're going to be fair. We know we can trust them. We know they're going to be decisive. We know they're going to make good decisions. If they make decisions we disagree with, then we can appeal them. We can fight them. We can argue with them. And it's all going to be respect at the end of the day. That's what you look for in a good judge. And they hold your feet to the fire, which I want. Bring it on. They hold their feet to the fire. Everybody's got to be playing by the right rules and the same rules. Peter, will you take a few minutes to look into Florida versus Brian Riley? It's similar to Koberger, 4 people unalived by a total stranger. Laura, yeah. And again, if you guys are interested in this, let me know. Because what we talk about is what you guys have questions, what you guys send me. That's how I found this hearing. So yeah, whatever's going on out there that you guys want me to break down, send it to me. Shoot it to my email, lawyeryouknow@gmail.com. It's even better if you tag me on Twitter/X or Instagram @lawyeryouknow on Twitter. Give me a follow there and tag me there if you see anything. And on Instagram, it's @TragosLaw. Somebody else already had Lawyer You Know, by the way. So if you see somebody's Lawyer You Know, not me on Instagram, it's Tragos Law, and it's pretty obvious which one's the real one. John, any updates on that case you brought up like a month ago? I think it was Barry Morphew. No updates that I've seen, but I'm very interested in that case, and it seems like you guys are too. So that seems like one we are absolutely going to be following and covering. Also coming up is Donna Adelson's trial. I think I'm going to do like a short about Donna Adelson and some of the stuff that's happening right there. But if you guys are interested in that, let me know in the comments. Make sure you guys all hit that like button if you have not already. And please subscribe to our channel. Going to jail isn't even as scary as seeing this. I don't know. I don't want to be in jail. I don't want to be in jail either, but I get what you're saying. All right. So that's all we got. I appreciate you guys joining me here and hitting that like button. Till next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouKnow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, This is Peter Tragos, the lawyer you know.